All right, so today we're going to discuss our second video regarding a rapper with the name of Dank Demoss. Her real name is Dajua Blanding. This was the case regarding the overweight rapper who ordered a Lyft vehicle in order to go somewhere. The Lyft driver arrived at her residence. We saw the video. It was terrible. It really was terrible. He told her that he would not take her in the vehicle, that she was obese, that she would break his car, and that they have XL vehicles, which are larger Lyft vehicles, at an extra charge for people of her weight. Uh, and he just kept going back and forth with her for a couple of minutes and then drove away. Outraged, Miss Blanding, sought legal assistance in order to go after Lyft and the driver for the shame, the humiliation, the emotional distress that she suffered. And you could sympathize with her, on some level. Have I'm sure she has ordered Lyfts and Ubers before, and she is a little overweight, but no one's ever told her you can't ride in the car. So uh, we discussed this last week regarding whether or not Miss Demoss, I'll just use her name, Miss Demoss, would have a cause of action under federal law, under the Americans with Disabilities Act. And we concluded that under federal law, obesity is a protected disability if you can show that it has a physiological origin to it. So in other words, we discussed if the obesity was caused from some type of immunological disease, some type of metabolic dysfunction, then it would be a protected classification under the ADA, the Americans with Disabilities Act. So we actually were able to locate the complaint. We do a little bit of digging to grab it because this was brought in the state court, circuit court of Wayne County of Wayne in Michigan, and it's a little difficult to get items online there, but we had a service, we were able to grab it. So we looked at the complaint, and the complaint does not allege any cause of action under federal law. Rather, the complaint is brought under Michigan state law, known as let me grab this right here. I'm looking at the complaint, known as the Michigan Elliott Larson Civil Rights Act. I did research this a little bit. It's an act that came about in 1976. It was Michigan's answer to discrimination. Now, many of you may be aware that a lot of states and localities have civil rights acts, have discrimination prevention acts that are a lot more broader and a lot more robust than federal law. Federal law, we could say, is the bare minimum. It's the floor. The ceiling is generally the state laws. So, for instance, New York, New Jersey, California are states that are known for having very robust anti-discrimination laws, civil rights laws. So is Michigan, apparently, and admittedly, I just learned that reading this case here. And in fact, the 1976 Elliott Larson Act, in its promulgation, almost 50 years ago, stipulated that if you're looking for a job, right, in terms of seeking employment, putting a job application in, it's against the law to discriminate based on somebody's weight. In 1976, Michigan said that. I mean, we still don't have that in federal law. I could tell you in New York, state law doesn't have that. I think the New York City law does, the administrative code. But here's what's interesting, what you have to understand about the Elliott Larson Civil Rights Act is that while it's illegal to discriminate based on someone's weight in terms of finding a job, keeping a job, staying at a job, the discrimination statute as it relates to public conveyances, taxis, going to a school, a building, being given admission to a movie theater, right? Weight is not a protected class. Now, I don't know if that was done intentionally. I don't know if that was a misstep by the legislature 50 years ago. But essentially, Ms. Demoss, in terms of Michigan state law, in terms of Elliott Larson Civil Rights Act, the only way that she could sue Lyft is if they discriminated her based on the traditional protected classes: age, sex, disability. That's about it. But weight is not a protected class for, we'll call it, public conveyance discrimination. So I read the complaint, and it appears the lawyers are aware of that because they are trying to turn this more into an employment discrimination than a public conveyance, public accommodation case. So in my opinion, as pleaded, this complaint lacks merit. Now, again, the only way this complaint could have merit is if she pleaded a complaint based upon Michigan's Disability Civil Rights Act, which has undergone itself lots of changes since 1976. But again, reviewing the Michigan I think it's the Public Disability Civil Rights Act, that Civil Rights Act is read in tandem with the Americans with Disabilities Act, which means that obesity would claim for obesity would require a physiological genesis to be proven. And I haven't seen it here. So in my opinion, based upon the research that I've done, researching the Michigan law, the federal law, looking at the complaint, Ms. Demoss does not have a case. Now, she definitely can take her case to the Michigan legislature, and I wouldn't be surprised if we see a bill coming out of Michigan, out of Lansing, where they actually, now increase the public conveyance, public accommodation portion to include weight. And you might see it here in New York too. You might definitely see an expansion of classes of discrimination for public accommodation. But as we sit here today, I can tell you Ms. Demoss does not have a case. So take it for what it's worth.